Good morning, everyone. Welcome to today's hearing. Today we're going to begin by hearing further evidence from Mr. Simon Cash, and then we shall hear witnesses from other witnesses from Artelia. Yes,
Mr. Chairman, good morning. Thank you.
Could you ask Mr. Cash to come in, please?
Thank you. Good morning.
Good morning, Mr. Cash.
Morning.
That's it. You get the water done and then...
Sorry, it's a bit like a ritual.
That's all right.
Mr. Chairman, I'm not sure the microphones are working in the room.
Well,
Shall I try? Is that better?
Oh, now. Yes.
Sorry, I was slightly off centre.
No, I don't think it was. I don't think it was you.
right. Ready to get going?
Yes.
Right.
Very good. Thank you. Yes, sir.
Mr. Chairman, thank you. Mr. Cash, good morning. Last night we were discussing the question of value engineering when we stopped. And I now want to go back to that subject into the spring of 2014, but now looking at the position after Ryden had been notified that they were the preferred bidder, as they were on the 18th of March 2014. Can we now go to the contractor induction meeting of the 1st of April 2014? These are notes we've seen before a number of times. ART 402256, please. Now, this is a meeting at which you were not present. But Mr. Booth and Mr. Blythe of Artelia were there, as we can see, and again they did the notes and checked them. Do you think you saw these notes after the meeting, soon after the meeting?
They would have been copied to me, yes.
Yes. Can we look at page 2, please, and look at paragraph 2.1? This is under the heading Proposed Savings Referenced in Tender Submission. And you can see there that cladding savings were discussed, and the note records there is a potential saving of up to £376,175 that could be realised through changes to the proposed cladding. Savings can be achieved by changing the material and the method of fixing. Changing from zinc to aluminium and using a face fixing rather than cassette would save the most money. Now, were you aware before this meeting of the figure of £376,175 for savings on face-fixed aluminium cladding that Ryden was suggesting?
I can't remember specifically if that was the figure, but Ryden's had been asked to price an alternative for aluminium cladding within their tender return.
Right.
I can't remember whether that was the same figure or not.
I follow. Do you know, or did you know, how that figure was arrived at?
At that point in time, no.
Right. Now, if we look at your second witness statement, please, at page 3, you say there at paragraph 11, in the third line, I am not aware of the extent to which Ryden may have benefited from any cost savings achieved through VE, as I am not privy to its profit margin on the project, i.e. the margin between its costs and the contract sum paid to it by the TMO. You see that?
Yes.
Now, it's right, isn't it, that Artelia's contract sum analysis allowed a 12.5% margin for contractors' overheads and profit?
Sorry, Artelia's contract sum, when you say contract sum analysis, are you talking about our estimate?
Yes.
Rather than the tender?
Well, it's called a contract sum analysis, which I think was produced by Artelia in July 2014. We can look at it if you like.
Yeah, sorry, when you talk about are you talking about the one that was completed by Ryden, or are you talking about our estimate?
Well, I'm talking about an analysis that, well, perhaps we should look at it to may help you. Can we please look at ART 405918? This is something called a contract sum analysis done by Artelia.
Yes, when we prepare it, it is unpriced. And it is not completed. We didn't put any figures in there. Those were completed by the tenderers.
Yes, I understand that. Well, let's just see how far we go then. If you go to page 20, please, and look at B12, we can see there that under B12, contractors OHP, overheads and profit, 12.5% included. And that's how you get to the 9.249 for Ryden. You see that?
That's how they've priced their tender, yes.
Exactly. So when I refer to this document as the contract sum analysis, that's because it was called that. But cutting through the detail, did you know, and looking at this document, it looks as if you would have done, that Ryden had allowed a 12.5% margin.
No, that's not the margin. That is the allowance that they had made for overheads and profit.
All right. Overheads and profit then. I'll take that. Now, did you know that on the 18th of March 2014, Harley had offered Ryden savings on the cladding of £517,000 for face-fixed ACM in place of zinc?
I wasn't aware of that, no.
You weren't. Had you known that fact, you would have realised, wouldn't you, that the statement at the meeting that there was a potential saving of up to £376,175 for the cladding was a false and misleading statement?
If I had known, yes.
Yes. If you had known, what would you have done about it?
I would have actually would have raised that as an issue, that that Rydens weren't passing on the full value of the saving and from their supply chain to the client.
Yes. And is one of the reasons for that, because otherwise Ryden would be making a secret profit over and above the 12.5% OHP.
Yes.
Were you aware, or did you ever become aware, at the time of the project, that is, that the savings offered by Ryden to the TMO were substantially less than the savings offered to Ryden by Harley, and that Ryden was thereby retaining more than the 12.5% OHP?
No, I didn't become aware of anything like that.
Now, can we go to your second statement, please? ART 407399. You answered some questions about savings in respect of value engineering, and this is at page 2, and I'd like just to look at paragraph 6 with you, if we can. You say there, where VE does achieve a cost saving, the party or parties who receive the benefit of that cost saving will depend on the stage in the project when the VE takes place. And then if we just skip down to the next paragraph, which is under the heading VE prior to the contract price being agreed, you say, if VE occurs prior to the agreement of the contract price, then the saving achieved in the VE process will only benefit the client because it should result in a lower contract price. The client will therefore be paying the contractor less for the works and will get the benefit of that saving. Now, by in practice there, you say in practice, do you mean that that's where there's no contractual obligation, but the contractor will anyway adjust his price?
No, this is prior to any contractor being involved. This is during design rather than during the construction phase of the project.
I see.
So this is pre-procurement.
Pre-procurement. I follow. And then you go on to deal with VE after the contract price is agreed at paragraph 8 and following. Well, let's look at that then. You say VE after the contract price is agreed it most commonly arises at the instigation of the client or its advisors when the price for the works exceeds its budget, although VE can also involve the client achieving value in ways other than just cost saving. Let me go over the page. For example, a material with a longer lifespan but the same price. You go on. And then you go on to say, when VE arises in the context of a client trying to complete the works within its budget, the benefit of any cost saving achieved through the VE will in practice go to the client because it will be reflected in an adjustment to the contract price. Does that tell us that in your experience, the whole of the VE goes to the client by way of a cost saving?
It should do. However, the contract doesn't make any obligation on the contractor to pass on any of the saving.
I understand that. In paragraph 9, you say, in answer to the question, specifically to what extent is a contractor or subcontractor obliged to pass on the savings it may make in such a process to the client, you say a contractor or subcontractor will not usually be obliged under their contracts to pass on the savings in a VE process directly or indirectly to the client, but in practice, as explained above, will do so. Now, this is exactly what you've just told us just now in the transcript, but if a contractor is not obliged to pass on savings, why would they do so?
In the spirit of collaboration on the project.
Is the effect of that you believe that it's up to the subcontractor to pass on the savings as a matter of, as it were, moral choice or commercial good practice?
I wouldn't know what the contract terms are between subcontractor and main contractor, so therefore I can't really say.
Right. Are you saying that it's actually really up to the contractor how much of the savings are passed on?
Yes.
And what would determine that decision?
It would be a negotiation between the client's professional consultants team and the contractor. If the contractor didn't feel that they wished to pass on all of the savings, that's for them.
Yeah.
But at the end of the day, obviously, from our point of view, it was to try and get the best position and protect the position for the client in terms of trying to get the price to an affordable level. Therefore, trying to make sure that the full saving was being passed on.
Yeah. You say it would be a negotiation between the client's professional consultants team and the contractor. Am I right in thinking that where a contractor decided that it wasn't going to pass on all the savings, it would nonetheless not do anything or say anything to lead the client to think that it was getting the benefit of all the savings?
Sorry, I don't follow.
Well, where you have a situation where a contractor decides to keep some of the savings from value engineering for itself, am I right in thinking that even though that may be the case, they wouldn't do anything or say anything to the client to lead the client to think that the client was getting the benefit of all the savings?
Correct, I think.
Yeah. Now, if we go back to the contractor induction meeting, and we don't need to see it actually, but we can see that a cheaper cladding option was proposed, and cutting a very long story short, it was ultimately accepted. Do you remember that?
Yes, but not with face fixings.
Did you or anybody else at Artelia perform any analysis or any breakdown of the savings offered?
We reviewed the savings and we looked at trying to get substantiation of what those savings were.
When you say you review the savings, being specific, did you review the savings being offered by Ryden to the TMO in respect of the ACM face fixed or cassette fixed?
We looked at a number of options, yes,
Right.
in terms of the financial evaluation.
Right. Did you look at the savings being offered by Harley to Ryden?
No,
You didn't do the
we weren't
comparison.
provided with that information.
I follow. So it was only the savings that Ryden were offering to the TMO, and is that
Correct.
because you only had access to what it was that Ryden was telling the TMO?
Correct.
I follow. Can I then turn to a different topic altogether, which is the role of Exova on the project? Can we look, please, first at ART 406247? These are the minutes of design meeting number 4 of the 25th of June 2012. And if we look at the first page, we can see who was present at that meeting. Paul Dunkerton from the TMO, Alan Dawson and Keith Bushell from Appleyards, as they then were. We can see, if we look down at appointments, you see a little bit lower down, it's third item down, it says AY, that I think is Appleyards, to instruct fire consultant. You see that?
Yes.
Do you think you saw these meeting notes at the time?
They would have been distributed to me, yes.
Yes. Is it right that that Exova was appointed to the TMO on the Calc project, or by the TMO on the Calc project?
I believe it was. I can't remember specifically.
Right. Now we can see that J. Lee, if you look at the distribution list, is the fourth distributee down on the list. J. Lee of Exova. That's James Lee. Do you know what circumstances led Exova being referred to in the distribution list for the meeting on the 25th of June in respect of Grenfell?
No.
Do you know how Exova came to be appointed to act as a fire consultant on the Grenfell Tower refurbishment at all?
Studio E issued a request for them to submit a proposal.
Right. You say Studio E issued a request, and we've seen something of that a little bit, well, around about this time, in fact, a little bit earlier in 2012. Were Artelia involved in Studio E's decision to request Exova to submit a proposal, as you put it?
No.
No. So they did it off their own bat, did they?
I don't know whether they were instructed to or whether they did it off their own volition. I don't know. I wasn't involved in it, nor Appleyards.
Did you know that Studio E were looking for help from Exova in mid-2012 in respect of the Grenfell Tower refurbishment?
When you say help, are you referring to help in respect of engaging Exova If that's the case, then it's not unusual to have a fire consultant on a project in addition to other members of the design team.
No, but my question is, did you know that Studio E were looking for help from Exova at that time in respect of this project?
I wasn't aware that they were looking for help.
No. Thank you. Do you know if anyone other than Exova, any fire consultant or fire specialist other than Exova, was ever considered to act as a fire consultant on the Grenfell Tower project?
I don't know.
Do you know what led to what we see in this note, AY to instruct fire consultant?
I believe it was a recommendation from Studio E to the client that Exova should be appointed based on their proposal.
I see. So I know that it's a rather succinct reference here, but was the position that Studio E thought it was necessary to have the assistance of a specialist fire consultant, wanted Exova to assist, and wanted Artelia to instruct Exova? Is that all we take from what you've told us in this note?
All I can say is that it was recommended that Exova be appointed as a fire consultant, and that Studio E had reviewed their proposal and said that they felt it was acceptable, and the overall action for Artelia was then to issue an instruction to say that the proposal had been accepted.
Do you know whether any steps were taken, or by way of action by Appleyards, to instruct a fire consultant, as this note says would happen?
The action was a note was sent to Exova confirming that they would be appointed by the TMO.
I see. But I think you say that you weren't involved in that.
That would have been done by Alan Dawson. In fact, it was done by Alan Dawson.
Right. Can we then go to the question of fees? ART 6088, please. This is an email of the 20th of June 2012 from Bruce Soanes to Chris Churchman and Andrew Cassell in respect of Calc, copied to Alan Dawson, Kevin Powley and David Hale. Who is Kevin Powley?
Kevin Powley was somebody employed on the Calc project.
Right. Okay. And this is about Grenfell Tower. And it says, Chris, Exova's appointment will be direct to the TMO. We will not be instructing them direct as we are on Calc. Exova are awaiting instruction for both the main component of the project and for a separate item, a fire strategy for the existing tower, which will cover fire access. Appleyards have been asked to do a review of team fees and scope. Alan, please confirm you will take this up with Mark Anderson. Now, this is a few days before the meeting on the 25th of June we've just seen, the design meeting number 4. Looking at the third paragraph, where it says Appleyards have been asked to do a review of team fees and scope, was that a review of Exova's proposed fees and scope?
I don't know what he was referring to.
Are you aware if anyone from Artelia did agree to perform a review of Exova's fees and scope, as this email suggests should happen?
No, and when it goes on to say, Alan, please confirm you will take this up with Mark Anderson, I believe that was because this was an additional requirement over and above our commission, and I don't believe that there was ever any particular instruction from the TMO to actually take this up.
Right. So far as you're concerned, does that take us to this point, that even though there was an indication that Appleyards would do a review of team fees and scope, in the end, the TMO did not instruct you, as their professionals, to conduct such a review?
Correct. I don't know who had asked us to do the review, and obviously this is a correspondence between Studio E and Chris Churchman, so we were only a CC to it.
Right. Now, turning to the fee proposals in a bit more detail, do you accept that it's within the skill set of a quantity surveyor to be able to provide advice on Exova's fees?
No, I don't.
You don't? So a QS wouldn't be able to identify or analyse a budget for fire strategy work on a project?
No, I don't. It's not part of the core skill.
It's right, nonetheless, though, isn't it, that Artelia did receive copies of Exover's fee proposals?
Yes, that's correct.
Yes. Can we go to SEA 6074? SEA 6074. Now, this is an email from Margaret Trina at Exover to Alan Dawson at our Apple Yards, copied to Bruce Soanes on the 25th of October 2012. But at the bottom half of that page, because this is a response to it, there is an email from Alan Dawson on the 18th of July 2012 to Terry Ashton, copied to Bruce Soanes and David Hale. And there it just says, Terry, I just wanted to drop you a short note to confirm that the client has now confirmed your proposed fee is approved, to which end we would now ask that you engage with Bruce at Studio E in respect of the above project forthwith. So just looking at that, it does look as if the TMO had confirmed that Exover's proposed fee was approved, and then you asked, or rather Alan Dawson asked, that Terry Ashton engage directly with Studio E. Do you know on what basis the TMO had confirmed that the proposed fee was approved?
I believe on the advice of Studio E.
I see. So Artelia had no role to play, are you telling us, in the approval of that fee proposal?
Correct.
I see. Now, if we go to the top of the page, so the email I first identified to you, Margaret Trina's email, that sets out the two proposals that Exover had made. And if you look at the first paragraph, you can see that there's a reference to a fee proposal for the upgrade works. Do you see that? £8,600 plus VAT for the upgrade works. Yes?
Yes.
And in the second paragraph, there is a reference to the existing acceptance of the fee proposal in respect of the existing condition of the building for the sum of £2,865 plus VAT. Now, just looking at the existing condition proposal, do you recall that there was in fact no existing fire strategy for the building?
Yes.
And the job of Exover, is this right as you understood it, was to write one from scratch?
It was to review, yes.
Well, it was to produce
Yes.
an existing a fire strategy for the building as it stood prior to the refurbishment.
Yes, I
Yes.
believe it was a fire strategy or a report on fire strategy.
Yes. Now, given that this was a proposed refurbishment of a 1970s high-rise residential block, the refurbishment project was contemplated at that stage to be a substantial and complex piece of work. Do you accept that proposition?
I'm not sure who had said that, but I mean, in terms of projects, they all have different complexities and different levels of difficulty. In terms of what was required on this project, it didn't seem to be overly complex in that sense,
Right.
or how I understand it.
Was that a personal view you had at the time, that the fire strategies, both of them, were neither of them particularly complex?
I can't comment on the fire strategies. I was talking reference to the project as a general.
Well, do you agree that for the existing building fire strategy and for the refurbishment fire strategy, both pieces of work were significant and substantial pieces of work for Exover?
I don't know. I've not done fire strategies before.
Right. Did you yourself or anybody else at Artelia ever actually consider the scope of Exover's proposals?
No, because it wasn't part of our remit.
I see. So you didn't consider whether the fees that they were quoting, as seen by Alan Dawson in this email here, were adequate to perform the necessary work?
No, because Studio E had actually requested the proposals and had reviewed them themselves.
I see. So you didn't check whether Exover had devoted sufficient time to the job or was proposing to do so, or put yourself in the position of checking Exover's quality?
It wasn't part of our role.
Whose role do you think it was, if not Artelia's role?
Studio E,
And why was that?
because they were the ones that had requested the proposals and had also identified what the scope of the service was.
Right. Can you explain why Artelia were involved at all as we can see that they were, both in June and July 2012, and then again in October 2012, if Artelia really wasn't involved in assessing the amount of the fee, its adequacy, and the scope of the work that was proposed to be done by Exover on both of these proposals.
As employer's agent, obviously we can act on behalf of the employer, on behalf of the TMO, in issuing instructions. And the TMO had actually approved the proposals that had been put forward by Exover and asked us to issue an instruction confirming that their proposal had been accepted and that they were to be appointed director of the TMO. And that is solely what we were asked to do. No other involvement at all.
I see. So does it come to this, that your evidence is that as EA, employer's agent, which was Alan Dawson's role at the time, your role was simply to make sure that there was a contractual link between Exover and the TMO, and look no further than that about what it was that Exover was to do and the adequacy of the price?
Correct.
I follow. So do we take it that you never actually, and nobody else, Artelia, actually ever did give any advice to the TMO about the scope of the proposals for both of these reports on the building that Exover were being asked to do?
Correct.
Did Artelia have a view at the time about whether these fees were adequate, given the amount of professional service required on a project of this complexity?
I didn't have a view, no.
Do you know whether Mr. Dawson had a view?
I don't know.
Can we then go to look at Exover and Artelia's role in the context of CDMC? I want to go back to where we were yesterday and look at Artelia's duties under the CDM regulations to ensure that competent designers and contractors were appointed. And if we need to go back to the ACOP, the Approved Code of Practice at paragraph 90, Mr. Cash, we can do that. Would you agree, though, generally, that Exover would come within the definition of designer for the purposes of the CDMC?
I don't know.
For the purposes of the CDM regulations? You don't know? Would you agree that a CDMC, a CDM coordinator, should have considered and provided advice on the competency and resources of Exover as a designer?
I don't know.
You don't know?
That would be, I'm not a CDM coordinator. Keith Bushell was the CDM coordinator, and he would have identified whether or not Exover were a designer under the definition of the CDM regulations.
Yes, and I'm really after your recollection. Was there any, to your knowledge, any discussion within Artelia about whether Artelia, or Keith Bushell in particular, as CDM coordinator, would consider and provide advice on the competency of Exover as a designer?
I don't know if he had in specific reference to this project. Obviously, Exover were engaged on the CALC project and had already been through a test of competency on that project.
Yes. But the fact that they've done that on that project doesn't necessarily carry across to this project, does it?
I can't comment.
Well, each project must carry its own set of standalone obligations, surely.
Yes, but in terms of the competency, because this was a follow-on project from the CALC project, I'm not sure what levels of checks were carried out by Keith Bushell.
Right. But you were Keith Bushell's supervisor as project director, weren't you?
Not his line manager, no. I was the project director for the project.
Yes, and as project director for the project, even though you weren't his line manager, you nonetheless had overall supervision or overall responsibility for the quality of his work.
Responsibility, not supervision. He was an associate director within the business and therefore was at a particularly senior level of being able to act autonomously and under his own authority.
Yes. Did you regard it, though, as part of your responsibility as project director for this project to make sure, nonetheless, however senior the particular role carriers were, that they knew exactly what their roles were?
That they knew what their roles were,
yes.
Yes. And that had already been defined. We'd had kick-off meetings and each person within the team knew exactly what their role was. Right.
Was there any discussion, so far as you can recall, between you and Keith Bushell or anyone else at Artelia about whether Keith Bushell, as the CDM coordinator, should have been examining Exover's competency and resources as a designer?
I don't recall any particular conversations that I was involved with, no.
Do you accept that under the CDM regulations, Artelia, as a CDM coordinator, had the obligation to ensure that designers complied with their duties, just as a general proposition of law. Do you
In
accept
terms
that?
of making sure that the clients were complying with their obligations, yes.
Well, maybe we need to look at the regulation. Could you please go to INQ 3011315, please? This is the CDM regulations 2007, and I want to go to regulation 20, about page 11 of this, if we can, please. And I want to go to regulation 20, sub-regulation 2C, and regulation 2 starts off, without prejudice to paragraph 1, the CDM coordinator shall, and then if you look at C, take all reasonable steps to ensure that designers comply with their duties under regulations 11 and 18.2. I mean, were you aware at the time that a CDM coordinator had that obligation?
Not specifically. I knew that they had obligations, yes.
In general terms, do you agree with me that completing a fire safety assessment of the proposed facade construction was fundamental to Exover's task of delivering a refurbishment fire strategy?
For the completed project or for the existing building?
For the refurbishment. You're quite right. For the refurbishment.
I'm not sure that I'm not sure whether it did or didn't. I know that obviously the fire strategy is there to deal with the operation of the building in the event of a fire and how people may escape from it, or how the fire brigade may attend to fires, etc. So that to me is the fire strategy rather than actually being a design document.
Right. What I'm really putting to you to try and cut through this is that Exover was a designer. They had duties under regulations 11 and 18 too, and it was Artelia's job as CDM coordinator to take all reasonable steps to ensure that they complied with those duties. That's the point I'm putting to you. Do you accept that?
I'm not sure what regulations 11 and 18.2 are.
Right. Let's then turn to Exover's OFSS, the outline fire safety strategy for the refurbishment. When you were working on the Grenfell Tower project, Mr. Cash, were you aware of the three issues of the outline fire safety strategy, or OFSS, produced by Exover for the refurbishment?
No.
Right. Did you, or to your knowledge, anybody else at Artelia ever read these reports when they came in?
I didn't. I don't know if anybody else in Artelia did.
Just to try and prompt your memory, there were three of them. The first one was the 31st of October 2012. The second was the 24th of October 2013. And the third one, the third issue, was the 7th of November 2013. Those dates, do they ring a bell with you?
No.
Right. Would you have expected an employer's agent to read those documents when they came into you?
No.
Why is that?
Because they were documents that were either documents to help the TMO in terms of operational issues in relation to the existing building, or in terms of operational issues in the future building based on the design that was being developed.
Would you expect the CDMC, the CDM coordinator, to read these?
No.
But the Exover was part of the professional team as defined in the EA requirements and the contract that you signed, was it not?
No, they were not.
They were not. You didn't regard Exover as part of your professional team, is that right?
No, they weren't identified as a member of the professional team. There were only three people, apart from Artelia, that were identified as the professional team.
I see. So did they not become part of the professional team by reason of working on this project?
No, because they weren't identified as an additional member of the professional team by the client. They became a subconsultant. Sorry, they became a direct employee to the TMO under contract and worked alongside Studio E, Max Fordham, and Curtains, but they weren't identified as a member of the professional team. No.
Can we then go to EXO 401106? I just want to see how far we can get with this document in the light of the answers you've just given me. This is issue 3 of the outline fire safety strategy for the building, dated the 7th of November 2013. Just looking at its first page, is this the document you think you ever saw at the time?
I can't remember.
Right, let's, we may not get very far at all, but let's just look at page 4 if we can, and maybe try this out on you. Page 4 is the introduction, and it explains what the refurbishment comprises. And there are 5 bullet points, none of which identify the overcladding. And then it goes on, this report details the applicable statutory controls in respect of fire safety and contains an outlined fire safety strategy for compliance with these statutory controls. If that had come into Artelia, do you expect that the person receiving it would have read that page?
I don't know.
Right, I don't know. Can we go to page 9 then and look at paragraph 3.1.4, compliance with B4 external fire spread? This says, it is considered that the proposed changes will have no adverse effect on the building in relation to external fire spread, but this will be confirmed by an analysis in a future issue of this report. I'm assuming from your answers you've given me that you weren't aware that each of these reports, and I say each issue of the OFSS, October 12, October 13, November 13, said exactly what is said there under 3.1.4, which is that in relation to external fire spread, the adverse effects would be, or lack of them, would be confirmed by an analysis in a future issue of this report.
I wasn't aware of that, no.
No. Did you ever see anything that would lead you to think that Exova ever provided an analysis in a future issue of this report?
I haven't seen, I don't remember seeing anything.
No. Do you accept that Artelia, as a CDMC, should have ensured that Exova, as a designer, did produce a final report addressing the impact of the overcladding work on external fire spread, as they indicated they would?
No, I don't believe it is part of the CDM coordinator's role to manage design issues or to manage production of fire strategies. Its role as CDM coordinator would have been to collect the information for the health and safety file at the end of the project. But obviously, that didn't happen because of changes in legislation.
Right. Now, earlier we looked at the contract, and let's look at that again. ART 405742, please. I want to just look at page 63 in the light of what you've just been telling me, just to get back to it. This is the CDMC Schedule of Services, and at the top half of the page, this is ART 405742, page 63. This is under the contract that you signed with the TMO, Mr. Cash, and it says, and this is the second bullet point I want to show you, work with the project team with a proactive approach to ensure that the schemes are designed and delivered incorporating all relevant requirements to achieve statutory compliance. Did you understand at the time that that obliged Artelia to work with Exova and the TMO to ensure that the B4 requirements of the building regulations were properly addressed by Exova and completely addressed by them?
No, because it wasn't to actually carry out the design or carry out any reports, or it was to work with them in terms of ensuring that designs met the requirements in relation to working safely on site, and also in terms of being able to maintain safely after the work's been completed.
Can we just go back to page 8 of this document? Because you said earlier in your evidence that Exova weren't part of the professional team. I just want to, particularly in the light of what I've just shown you, examine that again. The definition of professional team here means the consultant, the professionals listed in the appendix, and then this, any other professionals engaged by the client in relation to the project, and which the client notifies to the consultant. Now, we know that Exova, as you've been telling us, were engaged by the TMO, who is the client. Why do you say that Exova weren't a professional who were part of the professional team as defined?
They weren't actually notified as an additional member to the professional team. They were just engaged as another consultant.
They were engaged as another consultant. Were they not notified to you? Why do you say they weren't notified by the TMO to you?
They were notified as an appointee, but they weren't notified as another member of the professional team.
that's an interpretation of the provision. Can I just understand what you understood at the time, what it was that notification involved within the context of that definition?
That it would be it would be a variation to the names that were already listed within the appendix.
That would have to be done formally, would it?
I believe so, yes.
Right. Why wasn't the communications that we saw in July 2012 about Exova being engaged to perform two analyses of the building sufficient notification to bring them within the definition of professional team as you understood it?
Because I didn't feel it was. There were others that I believe there were other people were also consulted and we didn't become part of the professional team either.
Well, who are those others that you?
I can't remember specifically. I can't remember specifically, but I don't believe that Exova were actually part of the professional team. The professional team was limited to Studio E, Max Fordham, and curtains.
Right. I thought, maybe I'm wrong, that Artelia's role, at least in part, was to identify risks in respect of the project and gaps in respect of professional expertise. How could Artelia carry out that role if they didn't read these documents, the outline fire safety strategy and the existing fire safety strategy?
So I don't see the correlation between the two. The risks that you refer to were actually risks to there was a risk register which was produced, which was looking at risks in terms of the delivery of the project, and those related to particularly risks such as things like planning, finances, contractor insolvency, etc. There were also reviewing roles and responsibilities of the professional team in terms of making sure that there was no overlap between their appointments or in terms of their understanding of their roles and responsibilities or any gaps. So I'm not sure in terms I feel that there's sort of a mixing up there of what you're saying.
Right. I'm just puzzled here because as we've seen specifically in respect of the CDM regulations, which obviously applied, and the role of the CDM coordinator, why was it not the case that the CDM coordinator had an obligation to ensure that Exova, as a designer, was carrying out its own health and safety obligations, which were imposed on it under the regulations?
The health and safety, the CDM coordinator issues a health and safety risk register, which is for each of the consultants to complete to ensure that they are reviewing and ensuring that their design, where there may be risks in terms of their design, are being mitigated in relation to works being carried out on site safely, and also in terms of works that, to be maintained post completion of the works.
Right. Well, let's see how we go then on this. ART 402256, please. These are the minutes of the contractor induction meeting of the 1st of April 2014, which we've seen before. Again, we don't see you weren't at the meeting, but we looked at this a moment ago. If we go down to this time point 5.3 on page 4, please. It says there, underneath novation of designers, you see it says under 5.3, Exova completed the fire strategy at tender stage. Were you aware at the time that it was being said at this meeting that Exova had completed the task of delivering a fire strategy at the tender stage?
In terms of what they'd been engaged to do, I presume that's what it was relating to, yes.
Looking at it now, do you accept that that was wrong and misleading, given that an important part of Exova's work, namely the much promised future analysis of external fire spread under B4 of the building regulations, remained outstanding?
There would have always had to have been a fire strategy completed at the end of the project, because there is still design to complete. And you can't carry out and complete an overall fire strategy until you have all of that information. This, to me, is saying that they completed what they were required to do at tender stage in terms of the documents that were issued then.
Right. But we know that the fire strategy wasn't complete at the tender stage, which is in and after November 2013, because Exova's report expressly said that there was a future analysis still outstanding. That's why I put it to you in the terms I did. It wasn't complete, was it?
It was complete as complete as it could be at tender stage. And I believe, I don't know in terms of their terms of appointment, but they would never have been completed as a final document. It wouldn't have been until the end of the project. And as I say, my interpretation of that, it was completed in terms of what was required and what could have been completed at tender stage.
Well, you say it was as complete as it could be at the tender stage. What's the basis for for that view, Mr. Cash?
Because the design was still evolving and still had to be completed by Rydens. And
Yes.
until the design is complete, you can't actually complete the fire strategy.
The design may not have been complete, but it was sufficiently advanced to be able to form the basis of a tender. And so the question then is, why wasn't the Exova fire strategy sufficiently complete at that stage in respect of the overcladding design and materials to be able to form a view, at least, about the safety of the design as it then stood?
Because in a design and build contract, the design is not complete at tender. It still has development to be carried out by the contractor. And that therefore means that you cannot complete all of the necessary documentation that has to be in place at the end of the project. If you were going down a traditional route, then the design would have been completed to a much greater level of detail.
Yes. You see, the problem with that is that there's absolutely nothing in the Exova report at all, the OFSS at all, about the cladding. Whereas, in fact, the tender stage documents, which went out to the tenderers, had quite a bit in it about the external overcladding. So, hence my question. I don't understand how you can form the view that it was justifiable that there should be nothing in there at all about the fire strategy at the tender stage.
I didn't say there was nothing in there about fire strategy. I just said
about
that
the external fire spread.
Sorry, in which documents?
In issue 3, indeed issues 1 and 2 of the OFSS.
I wouldn't know. I didn't read the documents.
No. Right. Can we then turn to the question of, well, before we leave that, if you're right, is it right that Artelia would have expected a final fire strategy to be delivered by Exova to the client once Ryden had completed the design?
I would have expected Ryden to deliver a final fire strategy as part of their role as the design and build contractor.
Yes.
Not necessarily Exova. There was no requirement that Ryden actually engage Exova, albeit that there had been minutes that identified that they were going to appoint them. There was no obligation on them having to do that. They could have appointed anybody else to do that.
Indeed, but would you not have expected, given that Exova had been appointed and had done some work, for Exova to have finished their work off at the stage at which the construction was completed? No particular expectation that it would solely be Exova that would have done that role. It could have been, as I say, somebody else. But somebody else being a specialist fire consultant?
Somebody with specialist fire strategy knowledge.
Yes. So that's a gap, isn't it? The fact that there wasn't one is a gap.
I don't know. I don't know whether or not a fire somebody was engaged as part of the design and build supply chain.
Did you realise at the time that Exova never was engaged by Ryden following Ryden's appointment as main contractor?
No, I wasn't.
To your knowledge, did Artelia ever give any advice to the TMO, or indeed Ryden for that matter, that Exova needed to be properly engaged by Ryden, specifically to ensure that the fire safety of the external cladding was properly considered by a specialist fire consultant?
It wasn't our position to tell anybody who to engage. If Ryden decided to engage somebody else other than Exova, that was their decision.
Yes, indeed. But you could see, or Artelia could see, from the 1st of April meeting, that there had been a report at the tender stage. Leave aside the question we've debated about whether it was complete or not. My question is, did Artelia ever tell the TMO that Exova needed to be properly engaged to complete their work and to ensure that the fire safety of the external cladding was properly considered?
No, because it wasn't our role to tell them.
Wasn't it part of Artelia's role as employer's agent?
Not to tell them that they had to engage Exova, no.
Why is that?
Because, as I say, it could have been any other fire consultant that could have carried out that fire strategy on behalf of Ryden's.
Right. I understand the difference, the distinction you're drawing between X over and an other. So I'll ask my question in a different way. Did Artelia ever advise the TMO that a specialist fire consultant or engineer needed to be properly engaged to complete the work and produce a final report, and so that the fire safety of the external cladding was properly considered?
It was been part of the employer's requirements.
Yes.
And part of Rydon's duty.
You accept that it was part of the employer's requirements to do that?
Yes.
Yes. And so the question arises, did you ever advise the TMO that they needed a final and comprehensive report on the fire safety strategy of the external cladding by any specialist, whether it was Exova or somebody else?
Not specifically, but I know it would have been identified in the design reports that there was still further work to be carried out.
Indeed. And given that there was further work to be carried out, whether by Exova or by somebody else, was it not Artelia's job to make sure that that happened?
It was identified, I believe, in the Stage D report.
Was it Artelia's job to make sure that that happened, Mr. Cash?
I don't believe it was. No, it's part of Rydon's duty as the design and build contractor to ensure that it happened.
But was it not part of Artelia's duty under the morass of contractual obligations as we've seen in the contract that was signed in July 2014?
I don't believe so, no.
Were you aware of the contractual basis on which Exova was used by the TMO after the appointment of Rydon, as we've seen?
No.
We've seen various instances where, in, for example, September 2014 and again in March 2015, ad hoc advice was sought by Rydon and given by Exova in respect of various aspects of the external wall construction. Do you know the basis on which that advice was sought and given, the contractual basis?
No, I don't.
Did you ever consider the question of whether it was appropriate to use Exova on an as and when required basis?
No, because I wasn't aware that they were being used on that basis.
I'd like to turn to a different topic now, which is the change in the CDM regulations. Now, we've talked about the role Artelia was contracted to perform, namely the role of CDMC under the 2007 regulations. Before I do that, I would want to pick up a question I should have asked you just a moment ago. Have you or Artelia ever, to your knowledge, done a project which has involved a facade consultant or specialist facade engineer?
I believe within Artelia that there would have been in projects that would have involved a facade engineer, yes.
Yes. Were they quite common in the years 2012, 13, 14?
I can't remember.
Right, you can't remember. You may not be able to remember specific instances, but do you not have a recollection of, in general, whether facade consultants were commonly used in respect of high-rise overcladding projects?
The high-rise overcladding projects were not common projects at that point in time.
Any overcladding projects, whether high-rise or not?
There are some projects. I wouldn't say it's difficult to say whether it's common or not, but I have been involved in projects where there have been facade engineers, particularly where buildings have been reclad.
Did you ever consider yourself, or to your knowledge did anybody at Artelia consider, whether a facade consultant would be appropriate in respect of the Grenfell Tower project?
No.
Why is that?
Because we weren't engaging the design team, and in projects where facade engineers have been engaged, it's normally at the instigation of other members of the professional team who have identified that the projects are particularly complex or have a requirement for a facade engineer.
You say you weren't engaging the design team. That may be true post-tender. What about before the tender? Did you ever consider at that stage whether a facade consultant would be appropriate for this project?
No.
And again, why is that at that stage?
Because it didn't occur to us that one was necessary,
right,
based on the other consultants that are being appointed and what their duties were.
Right. So, presumably, I'm right, it would follow that you never had a discussion with the TMO, or indeed anybody else, that they should consider obtaining the services of a specialist facade consultant.
Correct.
Right. Can we then go back to where I was about to go next, which is the CDM regulations change? We discussed earlier on, I think, in your evidence, that the basic legal position changed in 2015, so far as the CDMs are concerned.
Yes.
And there was a transitional period, I think, between April 2015 and October 2015. And after that, after October, I think it's October the 5th, 2015, there was a new regime in place.
Correct.
Yes. Did you also know that the role of CDM coordinator, was abolished in the 2015 regulations?
Yes.
And it was then replaced with the role of principal designer. Is that
Yes.
right?
Correct.
Can we go to INQ 3011316, please? These are the CDM regulations 2016 themselves, and if we go to page 6, we can look at regulation 5, which provides, and you can see, appointment of the principal designer and the principal contractor. Were you familiar with these regulations in the period between April and October 2015?
I knew that they were in existence. I wasn't familiar with the contents, though.
All right. Can I just focus then on subpara or subregulation 3? If the client fails to appoint a principal designer, the client must fulfill the duties of the principal designer in regulation 11 and 12. Were you aware of that rule?
I became aware of it, yes.
And just to be clear, regulation 11 pertains to duties in the pre-construction phase, and regulation 12 in the construction phase itself and the health and safety file. Did you know that?
Not specifically, but I was aware that they would assume those duties, yes.
Right. So for this project, I think it's right to say, just to tell me if this is wrong, the effect of the 2015 regulations was that there was no role of CDMC after they had come into force.
After the end of the transition period on the 5th of October.
Yes. And that at that point, the TMO, as the client, had to appoint a principal designer.
Correct.
Yes. And if the TMO did not appoint a principal designer, then the TMO had to perform the role of principal designer itself.
Correct.
And in doing that, then discharge the duties of principal designer in regulations 11 and 12, as we can see here.
Yes.
Yes. And that law came into effect on, I think I said the 5th, it's actually the 6th of October 2015. Yes?
Yes.
Yes, that's the date. Now, I think you, tell me if this is wrong, but are you aware that the TMO have criticised Artelia for only giving them 2 weeks' notice to find and appoint a principal designer?
I'm aware that they have said that.
Yes. Would the TMO have been able to appoint a principal designer after the 6th of October 2015 if those 2 weeks didn't give them enough time to find one?
I believe that they could have appointed a principal designer, which would have then passed that role on to whoever was appointed. But in the intervening period, they would have been the principal designer.
Yeah. Let's move on with the story then, or rather pick it up in April 15. Do you remember that Keith Bushell was, until April 15, the CDMC? You mentioned him before in your
Correct.
evidence. And Keith Bushell was then replaced with Colin James as, I think, a subcontractor of Artelia.
Correct.
As CDMC. And then you referred, I think, earlier on in your evidence also to Paul Burrows, who I think was involved at the same time as Colin James. Is that right?
Correct.
And Paul Burrows was employed by Artelia, wasn't he?
Yes.
And he was also in a CDMC role.
Yes.
Yeah. Do you remember what the division of responsibility was between Paul Burrows and Colin James?
Not particularly, no.
Right. Can we look at your third witness statement, please? You set out there some instances where Artelia had discussed the rule change with the TMO in 2015. And if we can go to, first of all, ART 406286, please. This is an email of the 20th of July 2015. And we can see that the subject line in both emails on that page is F10, Grenfell F10. What is an F10?
An F10 is a form that is required by the Health and Safety Executive to be submitted in connection with carrying out works.
Can we go to page 7 of this email string then? And at the top of page 7, we can see that there is an email from Neil Reed of the 13th of July 2015 to Paul Burrows, and you're copied in on this string, do you see?
Yes.
And he asks the question, does Neil Reed, could you confirm if the F10 has been amended to suit the EOT to the 23rd of October 2015? Just to be clear, does the EOT mean or stand for extension of time?
Yes, it does.
And is it right that this email chain is about resubmitting an F10 form to the Health and Safety Executive?
Correct.
Yeah. And that was it because you had to do that because the completion date for the project had changed?
Correct.
And am I right in thinking that's a fairly routine matter?
Yes.
Yeah. Can we look at page 6 then? It's moving up the email chain and go to the bottom of that page. And you can see here an internal email within Artelia from Paul Burrows to Colin James, again copied to you. And he says in the third paragraph there, Neil, as this finishes after 6th of October, a principal designer needs to be appointed. If we're not in control of the design process, then we cannot accept this role. Please advise so we know which direction we need to take. And that email chain was then forwarded to Claire Williams of the TMO on the 20th of July. And we can see that at page 2 if we just jump up to page 2. And you can see that at the bottom of that page, Neil Reed, Claire Williams, 20th of July, revised F10 attached. You see that?
Yes.
Does that mean a revised F10 form was attached to this document? Again, you received it, as we can see.
Correct.
When you go to the next email up. In fact, actually, you're not copied in on this, so that's my mistake, but that's your understanding of it. You then say in your statement, your third witness statement, that Miss Williams should have understood from that email chain that Artelia was refusing to perform the role of principal designer. But if you look at the email in the middle of that page, Claire Williams says to Neil Reed, Neil, I'm not sure that Artelia should be the designer on the latest F10. You may want to check information on this earlier version. And I think you've suggested in your third statement that Miss Williams should have understood from that Artelia would refuse to perform the role of principal designer. Is that your recollection?
Yes.
It is. So let's just perhaps look at your statement. ART 409416, please, at page 4. If we can look at paragraph 16. If you look at 4 lines down into that, you explained that the email was forwarded on to Claire Williams in a chain on the 20th of July. See that?
Yes.
And in response to this chain, Claire Williams commented on 20th of July 2015 that she was not sure that AUK should be the designer on the latest F10 form and noted that AUK was an unlikely designer, exclamation mark. And then if you go to page 5 and look at paragraph 20, subparagraph B, you repeat the point just there. So the question then arises for me, why did you assume that Claire Williams had read 6 pages down into the email chain to see that Artelia was not willing to take on the role of principal designer and the reasons for it?
Because also she had identified that on the F10 that Artelia was being identified as principal designer and that she'd said that we were an unlikely designer.
I see. So you took from that she had read all the way down through the long string of forwarded email discussions within Artelia?
Not saying that she would have done necessarily, but that's what my assumption is, yes, and the fact that she commented on the F10 as well.
Right. Can you just tell me why was Claire Williams not actually told the reason that we see here, that Artelia was not in control of design, directly by you or anyone else at Artelia?
I believe there was another email which identified that she had to appoint a principal designer at a similar time from Colin James.
Yeah, we'll come to that. My question is, why was Claire Williams not told the reason at this point, namely that Artelia was not in control of design?
Because it was still because at that time Paul Burrows was looking for an answer that whether or not we were in control of design.
Right. Okay. Well, if we go to the top of the email chain we've got, this is ART, back to ART 406286. You can see that there was a mix-up with the F10. Just go to the top of the chain, page 1. Claire Williams comes back on the 20th of July and says, whoops, here is the one I'm asking you to check against. Artelia are an unlikely designer. Is it your evidence that this statement indicates that Ms. Williams understood very well in July 2015 that Artelia wasn't going to act as principal designer come October.
Yes.
Right. Now, as I say, you're not on this email chain, but you've given evidence about it in your statement, which is why I'm asking you about it. Can we then go to ART 404398? This is an email from Neil Reed to Colin James and Katrina Stoneley. And this time you are copied in on it. And it's also dated the 20th of July 2015. Neil Reed says, "Thanks for this. I have sent on to client." And he attaches a document. And the document is a revised F10 for Grenfell Road, apparently. And if we go to that document, that's at ART 404399. You see that? Here is the notification that you referred to earlier, at least generically, and it's dated the 20th of July 2015. If we look at the first page at the bottom, can you see that it says, about two-thirds of the way down the page, about those involved in the project? You see it says role principal designer, name Artelia UK Limited, email Colin James at Artelia. So that's showing that this document was telling the HSE that Colin James of Artelia is the principal designer.
This was the document that was sent to Claire Williams that she commented on,
Yeah.
saying that Artelia was an unlikely designer. I'm not sure whether or not this was the actual form that was finally submitted to the HSE.
Fair enough, but, and I think you've answered my question. So this is the document that was sent to Miss Williams, as we've seen from the 20th of July email that goes to her.
Yes.
Yes, and when she says Artelia are an unlikely designer, did you understand when you saw this, and I think you do because you've said so essentially, that she was expressing surprise that Artelia had put themselves down in this form, this F10, as principal designer?
Correct.
Because she's seen the F10 that was sent on to her, which you've now corrected. So returning to Mr. Reed's comments in his email, if we can go back to it, ART 404398, if we can please, he goes on to say, however, in the meantime, we are wondering if we should be the principal designer. And what happens in October 2015, we need to explain to the client who needs to do what. So at this point, can we take it that you and others at Artelia were alive to the fact that a discussion needed to be had about who was to be the principal designer on the Grenfell Tower project, at least come October?
Correct.
Can we then go to ART 404418? Because we now see Mr. James's response, Colin James's response to Claire Williams's email of the 20th of July. Here is his response of the 21st of July, and Neil Reed is copied in. You're not, I think, copied on that. And he says, "Hi Claire, the 2015 CDM regulations have replaced the CDM coordinator with principal designer, and the new F10 uses this title. Existing F10s will also change to the new format when they are revised, as is the case here. By to the 6th of October 2015, the client must appoint a PD, principal designer, under the new regulations for all new projects and existing projects that extend beyond that date." Now, it's clear from this that Mr. James's response doesn't highlight any difference between the CDM coordinator role that Artelia had at that point and that was going to disappear, and the new principal designer role, does it?
No, it doesn't.
And it doesn't spell out to the TMO the consequences to them as a client of not appointing a principal designer.
Correct.
Yeah. And looking at this response, do you agree that you could fairly read this email as meaning that the principal designer is a straight replacement of the CDMC?
Somebody might infer that, but I wouldn't necessarily say that is a given.
Yes, and you wouldn't say that as a given because it would be wrong. But and you would know why it was wrong, but it may be that somebody who less versed in the detail might think that a principal designer was being said to be a straight replacement for the CDMC.
Potentially, yes.
Yes. Can we then go to, this is an offline document I think we need, ART 409332. And if you can't find the offline version, we can try the non-offline version. This should be an email. It is an email chain of September 2015. Can we start at page 7 and 8? And just at the very bottom of 7, we can see Andrew Malcolm's email to Neil Reed of the 10th of September. You see that it's in two colours because Neil Reed, I think, has responded. But if you go over the page, you can see Neil Reed's response the same day, copy to you. Yes, that's that. If we go back to page 7, I'm so sorry. This is over 2 pages. This is the one I want. Neil Reed, 10th of September, to Andrew Malcolm, copy to you and Paul Burrows. And if you go then to page 5, well, perhaps we should just stick on that so that you've got the detail. He says, Andrew, read your email below. These are all good questions and exactly why I raised the email as I did to Paul, et al. On 21st of July. Re, what does Artelia need to do? Re, CDM 2015. We need to advise our client. Comments added below. And the comments are set out on page 7. Paul, please can you determine in conjunction with Simon Cash and then action whatever it is Artelia needs to do on this project to ensure client compliance with CDM 2015. Thanks. P.S. I assume you have an approach consistent with the situation on other projects. Thanks in regard to Neil. And then if we go to page 5, I just want to track this through with you. Page 5, at the top of page 5, you see Colin James comes back next day. You're copied in. Hi Neil, the client needs to appoint a principal designer prior to 6th of October 2015. I'm not sure what the scope of our involvement is on this project. However, if we have control over the designers, we can be appointed as principal designer. Please see attached appointment template. And then further up page 5 and on to, well, further up page 5, I think, you have your email to Neil Reed. Neil, I thought this question had already been raised with Claire, and we'd advised her that Artelia are not in the position to take on the principal designer role, and that the TMO should approach Rydens to take it on as they are in control of the design process now. So that's your response. And then if we go to the bottom of page 4, you get a response from Neil Reed, where he says, not formally to my knowledge, I think Paul/Colin should write to set out the situation and recommend action, although should letter come from you, query. And then, I'm sorry to take so long over this, Mr. Cash, go to the top of page 1, you can see in the second email from the top, Neil, simple fact is that we cannot act as a PD, so choices are to ask Ryden to take on the role. They are responsible for design, but they are not obliged to take it on. If not, TMO will have to engage someone direct. And then Mr. Reed says, OK, thanks, Si. That is my understanding, but I didn't know if Paul had found a way or desire for Artelia to provide it, given discussions at Wisley. Just on that, what do the discussions at Wisley refer to?
I'm not sure.
OK. Do you agree that even as at mid-September 2015, not even the employer's agent, Neil Reed, which he was by that stage, was sure if Artelia was going to act as principal designer come the 6th of October?
He was still looking to find a way as to whether or not we would or wouldn't. But there had already been prior discussions, albeit, as he says, it's not been formally noted, about the fact that we wouldn't take on the PD role.
Right. I mean, there'd been no formal notification to the TMO about the need for it to assume the role of principal designer, as at this stage, had there?
Not formal, no.
Or even, I think, informal, other than the discussions we've seen in July.
There may have been intervening discussions, I can't remember.
Right. Well, let's see. If you go to your third statement, you make a reference there. This is page 7. You make a reference to progress meeting number 15 on the 15th of September 2015. And if we go to the notes of that meeting. That's ART 406731, please. These are the minutes of that meeting. It's easier to take it from the minutes. Now, you weren't there, but you do refer to these minutes in your statement, so I'm assuming that you're able to answer questions about it. And if you look at page 7 of this meeting minute, Andrew Malcolm and Neil Reed were there, and it's an Artelia document, as they always are. If you look at page 7, at the top of it, page 7, paragraph 7.3, it says CDM 2015, CW to appoint a principal designer from the TMO's new consultancy framework. Now, do you accept that it wasn't until September, mid-September 2015, i.e. this meeting and in these minutes, that the TMO can really be taken to have understood that they needed to appoint a principal designer?
It was the first time that it was formally recorded.
Yes. And that being so, do you accept that this was the first time that the TMO were really firmly and clearly alive to the fact that they needed to appoint a principal designer?
I'm not sure what conversations had occurred prior to this meeting, but this was the first time, as I say, it was formally noted, yes.
All right. Now, we then move on to the appointment of a principal designer. We know that Artelia refused to perform that role on the Grenfell Tower project. Your reasons, I think, were that you weren't in control of the design. Is that right?
Correct.
And I think you do say that, actually, at paragraph 217 of your first witness statement. Can we then look at a different part of that statement at page 70, your first witness statement at page 70, because we here see how you describe how you told Claire Williams of the change on the 25th of September 2015, and you see what you say there. If you look at paragraph 222, you summarise a conversation in an email to Paul Burrows and Neil Reed on the 25th of September, and you've set that out there. There's no need to turn to that. But if you can see that the first part of it says, under the CDM 2015, the CDMC role terminates at close of 5th of October. The role of CDMC has been abolished and a new role created, that of principal designer. So it looks from that as if this is the first time you're spelling out to Claire Williams exactly what it is that's happening.
Because up to that point in time, there seemed to be an impression that Artelia would take on that role. And I wanted to make it absolutely clear, despite any previous conversations that may or may not have taken place, that that was our position.
Right. Well, perhaps we ought to look at the document. Can we see it? It's ART 406195. And this is an email to Paul Burrows and Neil Reed on the 25th of September 2015. And you say, Neil, Paul, I've just had a conversation with Claire to try and clarify what's been going backwards and forwards in terms of what the TMO need to do, as this seemed different to what Bailey Garner was saying to her. Just pausing there, Bailey Garner were who?
I believe they were a consultant on their framework.
What was their role in the Grenfell Tower project?
I don't know. I don't believe they had one.
Right. Why were they talking to her about this subject, do you know?
Because she had, I believe, talked to them as one of their consultants on the framework about taking on the principal designer role.
And you go on to say, what I've said is, the current role of the CDM coordinator ceases to exist as of 5th October. The TMO must appoint a principal designer. Bailey Garner are not prepared to take on the role, as they say the PD should be involved with the project from inception. And then there are other things too. But just on that bullet point there, that second bullet point, you are telling Paul Burrows that you have said to Claire Williams that the TMO must appoint a principal designer. And just going back to my point again, is this a record of that conversation in which you were really making it clear to the TMO, yourself at least, for the very first time?
Yes, in terms of spelling it out, because obviously it still wasn't, the message wasn't getting through from previous conversations, because the issue was going backwards and forwards between ourselves and the TMO, and they were still trying to push us to become the principal designer.
Now, you go on to say in the second bullet point, my response is that this situation is not common to this project, and many organisations are being engaged due to the transition of roles who have not been involved with projects since inception, such is the way of legislation. Does that mean that this problem about advising clients about them taking on the PD role was not confined to the Grenfell Tower project and was a generic problem across the industry?
Yes.
Right. Was it your view at the time that if no principal designer was forthcoming, then the TMO had the option of engaging somebody else? In other words, somebody not previously engaged on the project? Or really, do they have no choice and have to take it on themselves?
If they couldn't, if none of the existing members of the team were to take on that role and they didn't want to engage or they couldn't engage somebody else, then yes, they would automatically take that role on board.
Right. Let's look at the third bullet. You say, however, for this project, her first port of call should be Ryden, as they are the D&B contractor, and as such manage the design process and are responsible for the design. If Ryden are not prepared to take on the take the PD role on, then the next option is to ask if Studio E would take on the role through Ryden. Now, Ryden were asked whether they would be principal designers, weren't they?
I believe so, yes.
They refused, didn't they?
Yes.
Studio E were asked, weren't they?
Yes.
And they refused, didn't
Yes.
they? And at one point, I think, it seemed as if John Rowan and partners would perform that role. Do you remember that?
They had, I believe, expressed an interest, and Neil Reid had recommended that Claire Williams speak to them.
Yes. And what happened to that?
I have no idea.
Right. Now, if we look at see what Miss Williams says in her fourth witness statement, can we go to that? That's at TMO 20853-697, please. TMO 20853-697, and I'd like to show you the first page there. That's her additional witness statement, and we can go to page 4 of that, please, and then over onto page 5. I want just to look at paragraphs 20 and 21 with you. At paragraph 20, she says, on 1st of October 2015, I emailed Neil Reid highlighting various issues in relation to the project. In respect of the change in CDM regulations, I queried as follows, and then she sets out her query. CDM regulations change. As long as the project team agree the design is fundamentally complete, then we believe the provisions within the legislation allow KCTMO to request the principal contractor to compile the health and safety file and issue direct without the formal appointment of a principal designer. Can we get this put into the meeting next week and check that the team agree design is fundamentally complete and get this minuted? I believe the expression fundamentally complete came from a discussion with Simon Cash. That's what she says. And then she goes on. This email was formalising the discussion that I'd had with Neil Reid's manager. At this point, Neil was a consultant to Artelia and not based in their office. I cannot recall Neil Reid ever advising that this arrangement was unacceptable under the new CDM regulations 2015. A number of things follow from that. Would the design being fundamentally complete be a good reason for the TMO performing the role of principal designer?
It wouldn't be a prerequisite in terms of them performing that role. I think it's just it was a point in time. I don't recall the term fundamentally complete, but we probably would have had a discussion at the time about where the project would have been relative to when it was going to complete on the 23rd of October and the changeover on the 6th of October.
Who was it who came up with the idea that the design was fundamentally complete so as to justify the TMO taking on the role of principal designer?
That would have been the TMO. Nobody came up with a particular idea that it was fundamentally complete. As I say, I don't remember the term being used, but obviously at that stage in the project, if there was only going to be 2 weeks after the changeover, then the inference is that there should be no design left and that they should be actually in the handover period.
Well, we can see that she says in paragraph 21 that the expression fundamentally complete came from a discussion with you. What do you say about that?
I don't recall that.
You don't recall it. Can we just look at your third witness statement, page 7? I just want to go to paragraph 25 in that. You'd say there, commenting on paragraph 21, that she believes the expression fundamentally complete relating to the progress of design on the project had come from a discussion she had with me. I cannot recall whether I said this to her. At the time, the project was due to complete on the 23rd of October 2015. The design should have been near to completion at such a late stage in the project, so it is possible that I discussed this or something similar in nature with her. Is that still your evidence?
Yes.
Yes. Did you consider, when having that discussion with her, that the TMO would be giving themselves duties imposed by regulations 11 and 12 under the new 2015 regulations?
I knew that they would be giving themselves duties, but not necessarily what they specifically were under 11 and 12, because I didn't know what the specific wording of those regulations were.
And to your mind, what relevance is a design being fundamentally complete have to producing a health and safety file?
The design, well, to produce the health and safety file, there has to be information in there as to how to maintain and operate the building in a safe manner and carry out maintenance works in a safe manner. So it could be record information of the design once it is completed. Fundamentally complete is not complete. It has to be completed to actually fulfil or to prepare a full health and safety file.
Indeed. Did you advise the TMO precisely on what duties they were undertaking if taking on the role of principal designer?
Not me particularly, but I know that Paul Burrows did actually advise the TMO of the differences between a CDM coordinator and a principal designer, identifying what the principal designer's role was.
Right. You say Paul Burrows did. Do you know when he did or how he did that?
I can't remember specifically the dates, but I know it was probably around this time.
I see. Mr. Chairman, is that a convenient moment?
Yes, I would think it is. How are you doing?
We're doing quite well. We've got about probably another hour maximum on the questions I've prepared, and then there'll have to be a short break to see whether there are any other questions which are coming in from core participants. But that is very much a maximum.
Right. All right. Well, Mr. Cash, we're going to have a break now. We'll come back at 11:45.
Right, thank you.
And please don't talk to anyone about your evidence or anything to do with it while you're out of the room.
I won't. Thank you.
Thank you very much. We'd like to go with the usher, please. Right, 11:45, please. Thank you. Yes, would you ask Mr. Cash to come back in, please? Right, Mr. Cash?
Yes.
Yes, Mr. Millett.
Now, Mr. Cash, in your third witness statement, and I don't think we need to go to it, at paragraph 17, you say you had a conversation with Miss Williams about Artelia performing the role of CDM compliance advisor on the 25th of September 2015. We can look at it if you want to, but that's what you say there.
Yes.
Yes? Can we look back, please, at ART 406195? This is the email which we saw just before the break, which records that conversation. And in the last bullet, you say, you're telling Paul Burrows, the CDM compliance advisor role is not a project-specific role, but rather a client-side role, and one that we can fulfill. Advising clients of their obligations under the new regulations and ensuring that their project managers, PDs and PCs are all doing what they should be under the new regulations, similar to the role we are offering to Lambeth. Now, what tasks specifically did you think the CDM compliance advisor would perform?
Specifically, I hadn't considered in any detail, but it was particularly in terms of the health and safety file and making sure that the client or principal designer, if the client wasn't the principal designer, would be pulling together the health and safety file.
Right, I see. So the CDM, is it right that the CDM compliance advisor role that you referred to there would involve ensuring that the health and safety file was complete?
Not necessarily. It would be ensuring that whoever is responsible for it would complete it.
So advising, I see. So advising the TMO in this case that the health and safety file was of their obligations to ensure that the health and safety file was complete.
Correct.
Yes. Now we know that the TMO decided not to appoint a CDM compliance advisor. Do you know why that was?
They decided to take that role themselves.
Yes. Do you know why that was?
No.
Right. We then turn to the next topic, which is the TMO's own decision to perform the role of principal designer, which we know they decided to do themselves. Can we look at ART 409351, please, and go to page 3. This is an email from you to Andrew Malcolm on the 23rd of October 2015, copying other people from Artelia, as we can see, and it'll read Paul Burrows. And at the top of the page, in the second paragraph, you say there, Paul Burrows is responsible for all matters relating to CDM. Well, I should just show you the first line, actually, because it's relevant. I've spoken to Claire, but that was to say that we are not in a position to act as PD. Was that a later discussion from the one in September that you referred to? Or was it the discussion that you had in September?
I can't recall.
And you go on to say, Paul Burrows is responsible for all matters relating to CDM, and the action is with him to sort out what is going on. No one else is qualified to deal with this. By no one else is qualified, do we correctly understand you to mean that dealing with CDM requires specialist skills?
It requires to be qualified. Yes, it requires specialist skills because it needs an understanding of the regulations and the intricacies of those regulations.
Right. What would be a qualification? You say no one else is qualified to deal with this. What sort of qualification would you need?
I wasn't saying that he had a particular qualification, but he would be. He was a member of, I believe, ACOP, and that he was the business's health and safety advisor, corporate health and safety advisor, and actually had an in-depth knowledge of CDM regulations.
Right. Would you agree that the role of principal designer under the new CDM regulations, as they were in October 2015, was a specialist position requiring specialist expertise?
I wouldn't know whether it was a specialist position because, in fact, the role of principal designer is taken on by different types of people, whether it be a project manager or an architect or a contractor.
Whatever they were, would you agree that the role would require specialist knowledge and expertise?
It would require knowledge. I wouldn't necessarily say it's specialist. It would need an understanding of the regulations.
Right, fine. and an understanding of the consequences of the regulations and what they had to do under them, presumably.
Yes.
Yes. Did you think at the time that it was sensible for the TMO to perform that role itself, and what you knew of them?
They were an educated client, and they, as far as I was concerned, would understand what the role of a principal designer was, because they actually were carrying out other capital works within their organisation, and therefore this wasn't solely an issue on this project.
Did you have the view at the time that Claire Williams and those assisting her in relation to the Grenfell project had sufficiently specialist expertise and familiarity with all the obligations in the new legislation, the new regulations, to be able to perform their obligations as principal designer thereunder?
I don't know what level of knowledge they had specifically, but in terms of what was left to do on the project, I didn't feel uncomfortable in them taking on that role.
I see. So you didn't think that it was not very sensible for them to perform that role, and indeed do so without a CDM compliance advisor?
We were offering a service a bit like we did with the CDM design, as we did with the client design advisor role, where we felt that we could help support them. It was up to them as to whether or not they took that offer up.
Right. Now, can we then turn to a short topic, namely pre-construction information under the CDM regulations? I think it's right that under the 2007 regulations, the CDM coordinator had a statutory obligation to deliver pre-construction information to the main contractor. Was that your understanding?
Correct.
Can we look at RYD 3092644, please? This is the pre-construction information that Artelia provided in November 2013, and you can see it's dated the 25th of November 2013. Did you read this at the time it was released?
I can't remember if I specifically read through the detail. I would have been aware of that document.
Right. Can we look at page 14 and look at paragraph 2.14, please? Fire precautions. And it says there, in the second paragraph, the principal contractor shall not remove or displace any of the firefighting / fire protection arrangements provided for the normal operation of the building / area without first agreeing and arranging the implementation of adequate alternative arrangements. I think it's right that the pre-construction information document doesn't anywhere provide any information in the form of descriptions or drawings or the like to show the firefighting or fire protection arrangements, does it?
I don't believe it does, no.
No. And without that information, do you know how the contractor would know what they should do with the firefighting measures?
There would be, they would look at whatever record information there is in existence within the TMO.
Could you go to page 15 then, please, and look at section 2.15? This is entitled Emergency Procedures and Means of Escape. Refer to the following for details of means of escape, and you can see there what those include. Location plan, site area access plan, phasing plan, and other. And existing emergency procedures and fire plan. You see that?
Yes.
But again, as you've, I think, accepted, this document doesn't append those drawings or plans, does it?
I don't know if this is a document that sits within an overall pack of information that was issued for tender, so I can't remember whether or not those documents were included in the overall tender information pack that was issued.
Right. I see. I mean, it doesn't, on the face of it, give you any guidance as to what the plan is or where to find it or what number it has or anything like that. Any of these plans?
No, it doesn't.
No. Do you think that on that basis the pre-contract information was incomplete?
No, if the documents were included in the overall tender pack, then it would have been with Rydens to have checked everything that was in that pack.
Right. And if they weren't?
Then they should have raised a technical query requesting where that information was if it wasn't available.
And if they weren't, would you accept that the pre-contract information was incomplete?
If the information wasn't available,
yes,
then we couldn't have provided it. But that's where it should have been.
Can we then turn to the health and safety file? And I want to start with a discussion with you about the preparation of the health and safety file. Under the under the 2007 regulations, it was the CDMC, the CDM coordinator, who was to produce the health and safety file. Was that your understanding?
Yes.
Yes. Can we then just look very briefly at the regulations? They are at INQ 3011315, please. And at page 10 in that document, we can find Regulation 20, which pertains to the duties of a CDM coordinator. You can see the general heading there. And if you go over to page 11, we can see Regulation 20, Subregulation 2E, prepare, where none exists, and otherwise review and update a record, the health and safety file, containing information relating to the project which is likely to be needed during any subsequent construction work to ensure the health and safety of any person, including the information provided in pursuance of Regulations 17.1, 18.2 and 22.1J. Do you accept, looking at that there was a statutory duty to prepare a record of health and safety information relating to the project?
Correct.
Yeah. And then if we look to RYD 3092644, then, this is back to the pre-construction information report. I just want to go in this to section 3.14 on page 18. And it says there, existing health and safety file. A health and safety file as defined by the regulations is not available for this building. Now, in the circumstances where there was no health and safety file for Grenfell Tower at that time, so November 13, would you have expected Artelia to produce one?
No,
Why not?
because those regulations refer to not only refurbishment or projects, but also to new construction projects where there wouldn't have been a health and safety file. What it is saying is that the obligation is to produce one, but it doesn't say when, and as is normally the practice, if the information for the health and safety file is amassed during the project and the health and safety file is produced at the end of the project when all of the information is available and there's no further changes to be made to that information.
I'm not really sure I follow that. Given that Artelia was the CDMC, and given the obligation under Regulation 22E, which we've just looked at together, to prepare a health and safety file, why, and given that one didn't exist as at November 2013, why wasn't it Artelia's job in that role to produce a health and safety file?
It was, but as I say, it doesn't say specifically at that point in time. There was no information to prepare a health and safety file upon at that point in time. So therefore, we have to prepare one, and we can only prepare it based on the information that eventually becomes available from the various parties that are asked to supply that information. So the TMO, the contractor, and the designers supply the information that go into that health and safety file, and that plan was issued by Keith Bushell, identifying who the various parties were that contributed to that health and safety file. And you can't produce it without that information, so it's very much reliant on those parties to provide that information.
Right. I understand that answer. Did you, or anybody under your tutelage, ever spell out to the TMO as the client, or Ryden as the contractor as they became, what precise information you needed as the CDMC to be able to discharge your functions under Regulation 20, Subregulation 2E?
I didn't personally. I believe that Keith Bushell did.
I believe he did. Do you know when he did and how he did?
He issued a template identifying what information was required from which party.
And to your knowledge, how far did that get as at the October of 2015? How developed was it?
I don't know, but I would say it's probably quite limited because, as I say, that information is not normally amassed and gathered until the end of the project.
Can we then go to Artelia's contract again? It's ART 405742, page 61. I just want to go back to the schedule of the CDMC services that Artelia agreed to perform there. And if we look at paragraph 7, under those obligations, it says, give suitable and sufficient advice and assistance to the client on the following measures. And then there are various measures set out. And at item E at the bottom, subparagraph E, providing health and safety information for the health and safety file, Regulation 21A. You see that? So,
yes.
So the obligation wasn't only in the regulations, it was also part of your contract.
Yes.
And then if we go over the page to page 62, please, we could see paragraph 10. It says, liaise with the principal contractor on, and then item C, the contents of the health and safety file. Do you see that?
Yes.
And again, there's a reference to Regulation 21C, 20 Subregulation 1, Subregulation C, and then again over the page, or at the bottom of the page or lower down the page, to paragraph 13, prepare when none exists, or otherwise review and update the health and safety file, incorporating relevant information from other duty holders. And there's a reference to Regulation 20, sub-Regulation 2E there. And then under 14, immediately below it, deliver TWO, as opposed to TMO, copies of the health and safety file to the client, and that is the regulation, sub-Regulation F. Now, summarising it, do you agree that it was Artelia's duty under the 2007 regulations and the contract that we've just been looking at, first of all, to prepare a health and safety file where none previously existed?
Yes.
Secondly, to advise the TMO on the information to be put into the health and safety file?
And other members of, who would need to contribute to it, yes.
Thirdly, liaise with Ryden on the contents that were required for the health and safety file?
Correct.
Fourthly, to deliver 2 copies of that file to the client?
Yes.
Yes. Can we then go to INQ 30133936? This is the approved code of practice for the 2007 regulations, which we looked at before, otherwise known as L144. And if we go to page 58 in that document and look at paragraph 259, you can see that it says there what you must do, and there's a reference to, as you can see in the little box on the left, Regulation 20, sub-Regulation 1C and 2E, which we've been looking at in terms of the contract and the regulations. Can I just ask you, are you familiar with this document, or were you familiar with this document?
No.
Right. So you
I know of its existence, but I wasn't familiar with its with the detail of its contents.
Okay. Well, if we look at paragraph 259, it says, under what you must do, clients, designers, principal contractors, other contractors, and CDM coordinators all have legal duties in respect of the health and safety file. And then if you look a little bit lower down, A, it says, CDM coordinators must prepare, review, amend, or add to the file as the project progresses and give it to the client at the end of the project. Now, did you know, well, let me try it this way. Does that suggest, or did that suggest, if you've read this, I suppose, that the CDM coordinator should be compiling the health and safety file during the project as you go, not at the end?
As the information becomes available, yes.
Yes. And although, as you say, you weren't familiar with the details of this ACOP at the time, is that your understanding, that the CDMC should be compiling the health and safety file on an as-you-go basis once the information becomes available?
Once it becomes available.
And not leaving it to the last minute?
Well, it doesn't, if the information doesn't become available until the end of the project, then that is the only time that you have the opportunity to do so. And that is the normal course. That's the way. That's how projects normally run. Some projects have sectional completions or phase completions, in which case then the health and safety file is updated as those sections are completed, and that is how the industry interprets that particular requirement in terms of the regulations.
Right. So is it your understanding, just so I've got it, that even though this ACOP says that CDM coordinators must prepare, review, amend, and add to the file as the project progresses, in practice, your experience was that that didn't happen, and it was done at the end once all the information was available?
Yes.
Right. Well, let's then turn to what was prepared. Can we go to ART 404765, please? This is an email from Paul Burrows to Claire Williams on the 24th of September 2015. There it is on the screen. And you're copied in, and it says, "Hi Claire, I will be consolidating the CDMC document for the Artelia project so that it can be issued to the principal designer under CDM 2015. Now, what did you understand to be the CDMC document that Paul Burrows was referring to there?
It would have been any information that we have pertaining to the CDMC role that would be relevant to the principal designer role.
Can you give us some specifics? What
No.
would it have included? What did you understand it would have included?
I didn't understand it to include anything specific. It was a statement that Paul Burrows had made. I didn't think about what the contents of those documents might be.
Right. But you understood that the CDMC would be or include the health and safety file?
If we had any information, yes.
Did you divine from this, or did you have any other reason to think that you didn't have all the information you needed at that stage for the CDMC?
Well, I know that we wouldn't have had all of the information because the project hadn't completed at that stage.
Right, but it was very close to completion, indeed sufficiently close to completion for Claire Williams to think that design was fundamentally complete. Given that, and given that that was the basis on which she agreed to be principal designer, what was outstanding, or what was so importantly outstanding that you couldn't pull together the CDMC document, or, within that, the health and safety file at that stage?
I don't know what information had been received in terms of the information that had been outlined in the original template that had been sent much earlier in the project.
Right. Were you surprised that the CDMC document was only being compiled at this late stage?
No.
And is that because of the practice that you referred to before, that it was left until late on?
Correct. And also that our role in the project was coming to an end, and that we would need to hand over whatever information that we had to the principal designer.
What would you have expected to have been handed over at this stage? So we're looking at late or late-ish September 2015.
I didn't have any expectations of any particular documents other than what the CDM coordinator may have had received and what other information had been prepared. So there would have been the template for the health and safety file, certainly, and any pre-construction information, which the principal designer wouldn't necessarily have had a copy of if it was somebody else being appointed other than the TMO.
Right. Can we? I mean, we know that the project should have been completed by October 2015, and I think the revised completion date was the 23rd of October 2015, as we saw from the EOT reference earlier on. Given that the completion of this project was really imminent by this point, you're only a month away from the extended period, could you just explain why you wouldn't have expected more by way of documentation to be available, to be put into the health and safety file?
Because the project actually subsequently extended beyond the 23rd of October.
Well, you didn't know that at the time?
No, I didn't, but it was obviously the information hadn't been issued, or despite, I don't know what levels of requests had been made, but the information wasn't there and wasn't available.
Did it trouble you that it wasn't there and wasn't available?
It didn't trouble me because I knew that eventually, when we get to the end of the project, that a health and safety file will be amassed and produced.
Right. Well, let's see what was available at the time. Can we go to ART 409351, please? This is an email of the 23rd of October. Sorry. This is an email chain internally within Artelia, and this one is from Andrew Malcolm to Paul Burrows, copy to you on the 26th of October, but it has an earlier history. If we go to page 4, please, we can see that on the 23rd of October, Andrew Malcolm writes to Neil Reed, copy to you. Neil, apparently you have all the CDM information. Apparently Simon has spoken with Claire. Seems as if, Neil, can you send the information to Claire referencing conversation that she had with Simon? Again, that conversation, was that the one in September, or was there a later conversation about what the CDM information was that she would be getting? Do you remember?
I can't remember, no.
You can't remember. And if you go up the chain to the next email, he just on that page, Andrew Malcolm, it starts at the bottom of page 3, I think. We need to see that one. Neil Reed writes to Andrew Malcolm on the 23rd of October. We need to go back to the top of page 4, because it's split. It's copied to you. I don't have anything, guys, and whatever is being issued needs to come from Paul and or via Simon, does it not? You see that?
Yes.
And then if you go to go one email up from that to page 2, you write to Andrew Malcolm, 23rd of October, and say, Andrew, I've spoken to Claire, but that was to say we're not in a position to act as PD. This is an email we saw before in the context of a different discussion.
Yes.
Just putting it in its context. Then we go back up another email, please. And Paul Burrows comes back to Andrew Malcolm, a copy to you, as well as Neil Reed, and says, Andrew, the only information we have is attached. This includes, 1, reviews of the principal contractor's construction phase H&S plan, 2, the old and updated F10, 3, reports associated with the construction phase of the project, 4, agreed template for the H&S file. Best regards, Paul. Were you surprised at the time that this was the only information that Artelia had for the health and safety file at this time, late October 2015?
At that point in time, that's all that we would have received. Yes.
Yes. Were you surprised that it was so thin?
That there was no information other in the health and safety file. I wasn't necessarily surprised by it. It was a statement of fact.
Well, I know. Would you maybe try it a different way? By the 23rd or 26th of October 2015, would you have expected more to have been done on the health and safety file?
Well, on the basis that our appointment terminated on the 6th of October, we wouldn't have had any involvement beyond that in terms of collating any information for the health and safety file.
That may be, Mr. Cash, but I'm asking you whether or not, learning what you learned in late October about what was available for the health and safety file, did it not surprise you at that time, regardless of your continuing role, that it was so thin?
No, because quite often, as I said, information will come as in a lump at the end of the project, and we hadn't actually reached the end of that project yet.
Right. Well, let's go on to ART 409351. This is an email from Andrew Malcolm to Paul Burrows, copy to you, same day. Hi, Paul. With the greatest of respect, I don't think this can be dumped on the client like this, assuming you're expecting me to just forward this on. Or can it? Simon's email below infers, we've not discussed nor briefed the client in a CDM capacity other than to explain that we cannot act as PD. The immediate project team, Neil, Michelle and myself, whilst we are, quote, superstars, unquote, we aren't qualified or competent in areas of CDM. This goes back to my original email some time ago, now explaining that we need to have a process for handing over the CDM bundle and its associated components to the client. The message I'm getting back from both Neil, Simon and the client is that this has not happened despite the HSE deadline. Therefore, can I request that either you or Colin James or anyone from Artelia who is qualified or competent in areas of CDM arrange, happily through me, either a face-to-face handover meeting or even a call with the client ahead of any cold emails. This is so that the CDM bundle is passed complete with an explanation of the associated components. Please can we treat this as a matter of urgency, but by no later than the end of next week, 6th of November 2015, for this to happen. If anything, I personally want to stop looking daft at client meetings for missing a deadline. We, Royal Artelia, had 6 months plus to sort out, let alone any regulatory implications that may or may not have repercussions against Artelia. Now, a number of questions about that email, which I read in full to you. Would forwarding on the documents, or as it's put by Mr. Malcolm, dumping them on the TMO, have fulfilled Artelia's obligations and duties, did you think at the time?
In terms of handing over information?
Yeah.
Yes. Our role had come to an end and there was a handover process. And I believe that Paul Burrows had agreed to meet with Claire Williams and actually have a handover meeting, right, and pass documents on to her.
So you couldn't simply dump them on the TMO. Your thoughts at the time were in agreement with Mr. Malcolm, were they? You needed a handover meeting and explain what was there and what wasn't there.
Yes, and I believe that happened.
Right. Did you agree with Mr. Malcolm that the process of handing over a CDM bundle is one that should happen?
Yes.
And that should be done by what he calls the CDM team. Yes?
Yes, and I believe it happened.
You thought it happened? Okay. Looking at the last paragraph, which I've read out to you, Mr. Malcolm seems to be criticising Artelia, or individuals at Artelia, for their performance. Was there some friction between the employer's agents on the one hand and the CDM practitioners on the other within Artelia at this point on this project?
There appears to be, in terms of his own personal views, yes.
Did you know about that, given your role as project director on this project?
Yes.
You did. What did you do about it?
I tried to smooth the waters and tried to push to make sure that the handover process had actually taken place in terms of Paul Burrows making sure that he passed the information, and also in terms of the friction there, I felt that Andrew Malcolm was actually probably not in that email wasn't actually written in a tone that was acceptable in terms of an exchange between people.
Regardless of the tone, was it your view that the substance of his point was correct, namely that Artelia had been slow in sorting out this question?
I don't think there was any obligation on Artelia to actually sort out the client appointing a principal designer. We had made it quite clear to the client that we couldn't take on that role and that they would have to appoint a principal designer, or they would take on that role themselves.
Well, he is of the view that you've had 6 months plus to sort out this problem. Did you agree with him that you'd had 6 months to sort it out and had been slow in doing so?
I believe that we had, you're right, we had 6 months, and we had been discussing it with the TMO, and it hadn't been sorted, but I don't believe it was solely within Artelia's obligations to actually carry out any reappointment for the principal designer role. It was down to the TMO to take that responsibility.
Can we go to ART 409356, please? This is an email from Neil Reid to you on the 27th of October 2015. And he says, Simon, 1, CDM, following a further completion meeting today, it transpires that Claire has had no call from Paul. Accordingly, despite all the effort to ensure a smooth transition re-CDM, Claire considers Artelia's efforts in this regard appalling. Andrew and I were quite embarrassed by the lack of professional closure, and I think we all expected and planned for from Paul. Can you exert some pressure on Paul to wrap this up? Much in the way you suggested in a previous email, Claire still needs a CDM advisory type role and will probably bite Paul's arm off if he's able to offer this role. Saw that?
Yes.
And then it goes on. As at today, we have an expired F10 and a client expecting a handover of documents to include a partial H&S file. Someone will need to help compile a completed H&S file, so there remains scope for Artelia to see extra fee. Now, Artelia's efforts have been described by Claire Williams, according to this, as appalling. Do you agree with her assessment?
Only in respect that Paul had not contacted her to pass over the information that we had.
Right. Did you understand this email to be essentially an escalation of this issue to you as the project director?
Yes.
Did you take any steps to sort this out?
I would have taken steps with Paul to ensure that he actually did meet with Claire and pass over the information that we had.
Do you know whether there was any handover of documents or a file to the TMO?
I don't know specifically, no.
Did you not follow that through in your role as project director?
I can't remember.
Right. It was your responsibility to do so, given that this matter had been escalated to you, so I asked the question. You can't remember. What about Ryden? Was there any handover of the documents or a file to Ryden?
No, there was no need to hand over documents to Ryden.
Was a completed health and safety file ever handed over to the TMO, do you remember?
I believe it came from Ryden's to direct to the TMO.
Right, so not from you.
Correct.
Can we go to ART 405461, please? I just want to look at some different questions about Ryden during the construction phase. This is a formal complaint email from Neil Reid to Steve Blake of the 30th of March 2016, so late on in the project. Now, you were copied in on this. It's a longish document, and I'm not going to read it all out to you, but it starts out by saying, Steve, we are writing to set out our frustrations and concerns about a number of current issues with this project, as both the client team and consultant team hold the perception that Ryden could and should be doing more in the run-up to completion. And then you can see that there are 3 main topics set out: resource, meeting attendance, and handover matters. Now, did you, when you saw this email, did you read it, do you think?
I was aware of the email, and I had discussed it with Neil before it was issued. Yes,
I think in fact you also you saw this email before it was sent.
Yes.
You knew that it had been reviewed by David Gibson of the TMO before it was sent to Steve Blake. Is that right?
Yes.
Yes. Can we look at ART 406672, please? This is an email from Neil Reid to you, copying in others, relating to Ryden on the 9th of May 2016. You can see it there on the screen. 9th of May 2016. And this is now very close to the end of the project. And Neil Reid says, Simon, the O&Ms are unacceptable to the COWs, Clerk of Works. This is just a flag. This is becoming a farce. Despite all our efforts to ensure a smooth landing, I have to say I do not think I have ever worked with a contractor operating with this level of nonchalance. We are all getting sucked into doing far more than we ought to at this stage of the project. I'm wondering if you need to write to the TMO to express our concern and what we are endeavouring to do about it. Additional site visits, additional meetings, endless emails on design-related issues that don't concern us, as Claire is the design lead, etc., challenging the contractor, etc. Now, you see that Mr. Reid describes the situation as a farce, as he puts it, and that Ryden are operating with a level of nonchalance. Did you ever write to the TMO to express your own concern, as suggested by Mr. Reid in this email?
I can't remember if I did.
So we can't find a document showing that you did do that. And my question is, if you didn't do that, why you didn't do that?
Possibly because I would have had a conversation rather than writing.
Did these complaints about Ryden cause you any concern about the quality or the safety of Ryden's work?
No.
Did they cause you any concern about the regulatory compliance of the work that they'd done?
No.
Why is that?
This was regard to a process. It wasn't in regard to the quality of work that they had done. This was in terms of trying to close out matters in terms of documentation which they were due to produce to achieve practical completion and to ensure that they contained the right information.
Did you do anything in response to this email?
I can't remember if I did anything specific, no.
Did you take it up with Ryden yourself?
I can't remember.
Right. Thank you very much. Mr. Chairman, I've come to the end of my prepared questions.
Right, thank you.
This is the normal moment where we look and see whether there are others that I've missed or whether there are other questions that people want me to ask.
Yes. Well, Mr. Cash, as Mr. Millett said, he's got to the end of the questions he's prepared, but Council needs time just to take stock, and sometimes questions come in from people who are outside the room. So we'll have a 10-minute break at this point. Do you think 12:30
Yes.
will give you long enough?
Certainly.
We'll come back at 12:30 and no talking to anyone about your evidence.
Fair enough.
All right, would you like to go with the usher, please?
Thank you.
Mr. Millett, that's quite a short break. If you need longer,
Mr. Chairman, yes, thank you very much. Thank you.
12:30, thank you. Yes, would you ask Mr. Cash to come back in, please? Right, well, we'll see if Mr. Millett's found some more questions, Mr. Cash.
Yes,
Have you?
Mr. Chairman, there are a couple of follow-up questions of our own which we want to ask. Can I ask, please, that Mr. Cash be shown the contract again, ART 305742, and I want to go to page 48, please. At paragraph 1.3.3, we looked at this yesterday. One of the roles that was ticked was to establish the roles and responsibilities of the client, the professional team, which we could see we looked at this morning and has a definition, the contractor, and specialist stroke design subcontractors. And my question is whether or not you understood at the time that when it came to Exova, who were a direct contractor of the TMO, it was your role or your obligation, Artelia's obligation, to establish the role and responsibility of Exova within that network.
I believe that was identified within the project execution plan, that they were appointed as the fire consultant.
That being so, was it not your role and responsibility to make sure that everybody knew what Exova was doing and that Exova knew what it was doing?
That was within the project execution plan. The detail of their appointment was not something that was within our remit.
Why was it not within your remit?
Because we weren't responsible for appointments of consultants.
No, but were you not responsible for establishing the role and responsibility of Exova as a specialist stroke design subcontractor?
And that was as a fire consultant, yes.
Yes. Next question, or second question. Did you know whether the existing fire safety strategy, which had been compiled by Exova in the August of 2012 and had never progressed beyond a draft, has draft watermark through it, was included in the pre-contract information pack of November 2013?
I don't know if it was or not. I don't know if we had a copy of that.
Right. Do you know whether Terry Ashton's design note was incorporated or included in that document?
I don't know. Again, I don't know if that was issued to us.
Did you understand that that document or those documents ought to have been included in that pack?
If we knew of their existence, we would have made sure that they would have been.
Right. Okay. Thank you. Mr. Cash, those are the end of my planned questions. I have one more question for you, which is a question that I often ask certain witnesses in this inquiry. And that's this. Looking back on all the documents and the exchanges we've had over the last day and a half or so, and looking back over your own involvement in this entire project, is there anything that you would have done differently?
I think it's fair to say that if there was anything that we could have done or influenced that would have avoided the events that happened, then I think in hindsight one would say yes, there's always ways of doing things better. I don't think that we can say that we act with perfection, and that in going forward we always look at ways of doing better and improving on what we learn.
Thank you very much. Well, Mr. Cash, it only remains for me to thank you very much for coming to the inquiry and assisting us with our investigations. We're extremely grateful. Thank you.
Thank you. I'll do
Well,
my
Mr.
best.
Cash, it only remains then for me to thank you as well for coming to give your evidence. I'm sorry that we spread your evidence over more days than I think you were given to expect originally, but I'm afraid that was just unfortunate.
Circumstance.
Circumstances go that way sometimes, but I'm very grateful to you for coming to give your evidence. It's been very helpful to hear from you.
Thank you.
And now you are free to go.
Thank you very much. No questions from call participants then?
I don't know. Mr. Millett will have considered whether there are any questions and probably taken them in already, I think.
All right, thank you.
All right? So thank you very much. You'd like to go with the usher?
Thank you very much indeed, everyone.
Right, thank you, Mr. Millett. No, we'll have to rise, won't we?
We'll have to rise briefly.
Yes.
The next witness is Mr. Phillip Booth, and Miss Grange will be taking him.
Right.
We need a 5-minute cleaning break, I think, for
Yes.
that. And then I shall relinquish the podium for her.
Right, well, thank you very much. Well, we'll rise for a moment and you can ask someone to come and fetch us as soon as you're ready.
Very good.
Right, thank you very much. Yes, Ms. Grange.
Yes, good afternoon, Mr. Chairman. Could we have Mr. Phillip Booth, please?
Please read out the witness affirmation text.
I do solemnly swear, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Mr. Booth. Do sit down and make yourself comfortable.
Thank you.
Right? Yes, Ms. Grange.
Yes, thank you very much for coming today and assisting the inquiry with its investigations. It's very much appreciated. My questions are intended to be short and simple, but if you have any difficulty understanding anything I'm saying, please ask me to just repeat the question or put the point in a different way. If you feel you need a break at any point, just let us know. And please, can you try and keep your voice up so that the lady sitting to your right, just there, can take a nice clear note of what you're saying.
Sure.
Now, you've made 2 witness statements to the inquiry. If we can pull up the first one, ART 408527. And if we look at page 59, the final page of that statement, we can see it's dated the 27th of September 2019. And is that your signature there?
Yes, it is.
And have you read that statement recently?
Yes, I have.
And are the contents true?
They are.
Thank you. And if we go to your second statement, this is ART 409420. And this is a shorter statement. If we go on to page 4 of it, there we can see it's dated the 10th of March 2020. And again, is that your signature on that page?
Yes, it is.
And can you confirm that the contents are true?
They are true.
Have you discussed your statements or your evidence with anybody before coming here today?
No.
Thank you. So I'm going to start with just some questions about your background and your history. In your witness statement at paragraph 3, you set out your qualifications and training. If we just bring that up, this is in your main statement, ART 408527. I think it starts at the bottom of page 1 and then it goes on to page 2. So you tell us there that you graduated from Ashton University in 2001 with a degree in managerial and administrative studies. And then you say that you are a member of the Association for Project Management and that you've completed training in project management.
Yes.
Just to ask you a couple of questions about that. In little a there at the top, you refer to the Association for Project Management, APMP qualification. You see that there?
Yes.
When did you complete that?
I can't exactly recall, but it would probably be been about 12 years ago, something like that.
So some time ago. And Prince 2, you've referred to that in little b. Can you help us as to what that is?
It's a form of project management principles. It's born out of the IT industry, projects in a controlled environment. So it's a qualification that you can get in project management as to a particular type of methodology of project management.
Yeah. And again, did you complete that some time ago or more recently?
Again, maybe 8-10 years ago.
And you also say there in little c that you've attended various management and project management training courses and also industry-related conferences and seminars. That's right, isn't it?
Correct.
Is there any particular training that you have to undertake to become an employer's agent?
There's not an official qualification to be an employer's agent as far as I'm aware.
Yeah.
No.
Yeah. Now, at little c, you also say there, 3c, that you've got training in contract procurement. Can I just ask, do you have specialist knowledge of contract procurement?
I've learnt about procuring main contractors, different types of procurement methodology through ad hoc training events and through just experience over the last 15 odd years.
Yeah, I see.
I wouldn't say I'm an expert, but I am
Yeah.
very familiar with it.
Yeah. Now, then you go on in your statement at paragraph 5 and onwards, 5, 9 and 10, if we could look at paragraph 5 to start with. And what you do in those paragraphs is you set out some examples of the projects that you've worked on. So we can see that you're talking about, in paragraph 5, working as a project manager for Glencare, projects relating to mental health hospitals. And you outline a number of schools and hospital projects there. Would that be fair?
Yes.
Now, is it right that before the Grenfell Tower project, you had no experience in the overcladding of high-rise buildings?
So I'd been involved in projects that were in tall buildings, and I've been involved in projects that had cladding and curtain walling refurbishments, but not both together.
I see. Yeah. Did you have any experience of project involving residential buildings that were occupied?
So when I was at in my sort of hospitals, yes, some of those projects were carried out whilst the occupants of the hospital,
Yeah.
because it was their residency, were in place. So I had that experience. School projects were often done whilst schools were open,
Yeah.
but not a residential high-rise building, no.
No. Had you ever worked on any projects which involved aluminium composite materials, aluminium rain screen cladding being applied?
So some of the schools that I did have those type of systems put in, yes.
Yeah. And you tell us in your statement that you joined Appleyards, as it was then called, in January 2005, and you left there in April 2016, is that right?
That's correct.
And you now work for a different company doing project management, is that right?
Correct.
And you say that during your time at Appleyards, then known as Artelia after that, you went from being an assistant project manager to a senior project manager, which is what you were at the time of the Grenfell project, is that right?
Correct.
And then is it right that you ultimately became project director within Appleyards, is that right?
Yes. I was there about 12 years at the organisation, so
Yeah.
I climbed the ranks.
Can you help us as to exactly when did that promotion to project director occur?
I can't actually recall.
Right. Was it while you were working on the Grenfell project, do you think?
I don't think it was. I think it might have been after.
After, okay.
It would have been fairly close, though, perhaps.
Yeah. Now, in terms of your appointment to the Grenfell Tower project, is it right that you were assigned to the project in around April 2013, is that correct?
That is correct.
And is it right that your role was as employer's agent?
Correct.
And is it right that your start on the project overlapped with Robert Powell, who was also the employer's agent on the project?
Yes.
And did he leave the project in around July 2013?
He did. So we had a few months working together as a handover period.
Yes, I wanted to ask you about that. Was that simply a long handover with him, or was it intended that during that period you would both be working full-time as an employer's agent?
So we just took advantage of the fact that Robert was working his notice period because he was leaving the employment of Artelia, and when I came on board, it was quite a transition period of the project, and so it made sense to, have that transition and handover process.
Yes.
And with both of us working on it.
Yes. And is it right that you were assisted in your role as employer's agent by Peter Blythe and later Nick Valente? Is that correct? Have I said his name correctly?
Yes.
Yeah. And were they both assistant employer's agents?
Yes.
Yeah. And who did you report to on the project?
So on the project director for the project was Simon Cash.
Yeah. And that was who you were reporting to. Was your line manager somebody different?
It was.
Who was your line manager?
It was Bill Phelps.
Right. Now, you then tell us that in paragraph 22 of your first statement, I don't think we need to turn this up, that in around mid-June 2015, you were assigned to another project which required a full-time commitment. So is it right that your involvement in the Grenfell project ceased at that point in June 2015?
Correct.
And is it right that Neil Reed, a witness that we'll hear from after you, then replaced you on the project as employer's agent?
That's correct.
And he replaced you in March 2015, is that right?
Yes, that sounds right.
Now, it doesn't appear that you were assigned to another full-time project until June 2015. Can you help us as to what happened between March and June 2015?
So there was, again, a handover process that happened.
I see. So you were handing over during that time to Mr. Reed?
Yes.
And is it right that at the point that you joined the project, the TMO was considering whether or not to continue with Ledbetter as main contractor?
That's right, yes.
And when you left the project, Ryden was partway through the construction work?
Correct.
Yeah. Now, I'm going to start this topic. We won't finish it, but I'll start it. I'm going to ask you about the difference between an employer's agent and a project manager, and also something about those roles on this Grenfell project. Now, we've heard from Mr. Cash about the contracted services that Artelia performed, and that Artelia was not formally contracted onto the refurbishment until a signed contract in July 2014. Was that your understanding?
That's right, yes.
Now, can you just explain your understanding of the difference between an employer's agent and a project manager?
So an employer's agent is a defined role on design and build contracts to administer the building contract with the design and build contractor. There's a RICS scheme of works that's associated with an employer's agent and what duties they might not take. So it's a very defined administrative role for design and build projects. That's what I understand employer's agent is. A project manager is a far more wider descriptor, and it encompasses more. I am a project manager and so have fulfilled that role on other projects, continue to do so. The main sort of key difference, as I see it, is a project manager may well take on responsibilities outside of just administering the contract, the construction contract, and those duties can be written specific to the project. And it might be that they get involved more in things that are wider to the project than just the construction. So maybe communication outside the construction elements with stakeholders, maybe client-side elements to help with things that are outside just the administration of the building contract.
I see.
A project manager also may have sort of delegated authorities from the client to make decisions. Usually, employer's agent does not. They are administering the contract under the direction of the client. So I think the main difference is employer's agent is a more narrow scope of services for a design and build contract. A project manager can be much more far-reaching responsibilities with some decision-making authority if given by the client.
Yeah. Thank you, that's very helpful. When you were describing the employer's agent role, you said that that's linked very much to the appointment of a design and build contractor. But would you accept that prior to the appointment of a D&B contractor, an employer's agent may well have a role in coordinating whatever professional team the client had gathered together at that point?
Yes.
Yeah. Are the skills of an employer's agent broadly similar to those of a project manager?
There are similarities, yes. I think you need more skills to be a project manager than an employer's agent.
Yeah.
It's quite an administrative role, the employer's agent role.
Yeah.
And I think as a project manager, it is defined. You can get scope of services in the RICS, but actually it's quite a generic title and it can mean a lot to different people. So sometimes there is some confusion as to what is a project manager.
So you talked about there might be similarities. Would the similarities be in terms of the administrative aspect of the role, the administration of
Yes.
the contracts and administration relating to, the process of design or the process of construction?
Yes. In both roles, you need to be sort of organised and
Yeah.
write lists, diligent.
Is it sometimes common for construction professionals to use the terms employer's agent and project manager interchangeably? Is that a thing?
It
you come
is a
across?
thing in industry, yes. Yes, that is something that in the industry it does get chopped and changed around a bit.
Yeah. Would you agree that project management is a specialist skill which should involve some kind of formal training in project management?
I believe you should be formally trained in it to do it.
Yeah.
It's not like an industry like an accountant where you have to have achieved accreditation to do it. I think anybody can call themselves a project manager if they want to, but my belief is that you should have done the exams, you should have got the badges to do a good service.
Yeah. Yeah. In your experience, do most major construction projects have a project manager, properly so called, in the way you've just described?
Yes.
And what about major refurbishment projects? In your experience, would major refurbishment projects commonly have a properly trained project manager?
Yes.
But is it possible that you can have without one and just have an employer's agent?
It is possible, yes.
Would you agree that the Grenfell Tower project was a complex project to manage for either any employer's agent or indeed any project manager?
Yes, it was complicated.
And was it complicated in part because it was residential, with residents remaining in occupancy, and because it was an older building that may have been subject to dilapidations over time?
Yes, they were parts of the factors that made it more complicated.
Would there be any other factors in your mind that made it particularly complicated?
Well, there was a construction site behind that they were building the Kensington Leisure Centre and Academy. Idiosyncrasies of this particular job. Yes, residents were staying in occupation. That was a part that was specific to this project.
Yeah.
That's why TMO were heavily involved because
Yeah.
of that.
In your view, was this the sort of project that needed a designated trained project manager?
Somebody needed to fulfil the role, so yes.
Mr. Chairman, I think that's a good moment for a break.
Yes.
And now go into slightly more detail.
Yes, all right, thank you. Well, Mr. Booth, you've only just got into your stride, I'm afraid, but
Yeah.
given the hour, I think this is the time when we must have a break so we can all have some lunch.
Okay.
So in a minute, I'm going to ask you to go off the usher and be ready to return at 2:00, please. While you're out of the room on this or any subsequent occasion, please don't talk to anyone about your evidence or anything relating to it.
Okay.
All right.
Of course.
Right. Would you like to go to the usher, please? $2:00 then, please. Thank you.